All right, let's go back to our top story. Almost a year ago, Sandile Mantsoe was arrested as the prime suspect in the murder of his girlfriend, Karabo Mokoena. With the case now closed and sentencing expected to take place soon, could the handling of it in just 1 year have set something of a benchmark in terms of speed? Joining us via Skype is attorney and legal commentator Ulrich Roux. Ulrich, is this how the wheels of justice should turn?
Well, each case is unique, and the merits of each case is unique. I think what was unique about this case is that the accused person elected not to testify. So there was no defense case presented to court, and that would have reduced the time spent on this matter considerably. It was merely the state evidence presented in court, and the accused elected to close their case without leaving any evidence. And that would definitely have speeded the process up. But as I said, each case is unique, and I don't think that this is the benchmark necessarily going forward.
All right, so he made it easy for the court. Everyone is ecstatic, though, that it was swift, that no evidence was lost, that there was a solid case. Is all this ecstasy because we've placed the bar too low in the first place? We're concerned about how justice is being dealt with.
No, I don't think so. Remember that he has a choice whether to present the case or not. So the state needs to present the case. They need to lead evidence. They need to try and prove that an accused person committed an offence. And then the defence and the accused person has an opportunity to state their version. Now, if the state proves their case beyond a reasonable doubt, then the court should convict the person. Whereas if the accused person proves that his case is reasonably and possibly true, then the court must accept his version and must acquit him. But as I said, in this instance, the defence elected not to present any evidence. And the reason why they did so was because they said that the state had not proven any case for the accused person to answer to. So this was a strategic move by the defence. It's obvious that it did not turn out the way in which they wanted it to turn out. He did not plead guilty. He was of the opinion that no case had been proven against him, and henceforth he could not be forced to answer to the allegations. This we do see frequently in our justice system and in courts before the court. But when you make a decision such as this, you must be 100% sure that the state has not proven their case, and obviously the judge in this matter found that they had, and he found no reason why not to accept the state's version, and thus convicted him.
What do you expect in terms of sentencing?
Well, I think we must remember that the charge of murder, and if a person is convicted of murder, carries a minimum sentence of 15 years. So in other words, the Criminal Procedure Act and the Minimum Sentences Act prescribes that a court must hand down a 15-year sentence of imprisonment unless the convicted person can show substantial and compelling circumstances as to why the court should deviate from that minimum sentence. So in this instance, we would have to wait and see, the evidence that the convicted person does present in mitigation of sentence, and see whether he successfully can convince the court to deviate from that minimum sentence of 15 years imprisonment. But certainly that is the starting point for the court.
All right, thank you very much, attorney and legal commentator Ulrich Roux. We take a short